Kathy. Hi, Oscar.
Hello.
Hello. Well, good afternoon. This is our monthly meeting for Ask the quote unquote experts. And we are happy to be here today from the Innovation Law Center. Oscar, I'm wondering if you have a question. Kathy, I'm wondering if you have a question. If not, we could talk a little bit today about the importance of different types of agreements when working with others. But do either of you have a question to kick us off?
I don't. I'm here to learn.
Okay. Kathy, the session on FDA breakthrough technology was really great yesterday.
Good.
That was very helpful. And I know you have, you're hosting a manufacturers meeting, or what is it called? Next
Workshop.
Thursday.
Yep. From 8 to 3, 9 to 3. Yeah, there's a couple of them. And then our October 28th, promoting tech innovation in upstate New York. We just decided as of yesterday, to move that to fully virtual. The keynote speaker has noted that his preference now is to not attend on site, and a couple of the other speakers had the same. And we just feel that it's just safer. So that's going to be virtual too.
Okay. Well, I'm going to, let's see. One of the things that we get a lot, I think one of the best references we have is on our website, the series of guidebooks that we have. And we often, our focus, August, do you want to say a little bit about your background and what you're interested in? Okay.
Oscar. Yeah.
When working with others, we often get asked by people if we could look at an agreement that they're thinking of entering into. And the focus of our center is very much on research for the prior art, which includes patents, patent applications, both in the United States and worldwide, as well as academic publications, other publications, and products that are available for purchase. And within that context, there are many agreements that can come up while commercializing that new technology. And the research we do helps people make decisions about whether to move forward with patents or trade secrets, or maybe to focus on getting a strong trademark, the role the copyright might play. And so when we get asked about reviewing agreements, we always try to explain that our focus is on this research much more than, and that we don't review agreements because we're not a substitute for legal counsel, and agreements are very much a role of an attorney, and it's important to have an attorney take a look at agreements. Some of the agreements are founders agreements and licensing agreements, and we have guidebooks on both of those. Founders agreements are really important when you're co-inventing with someone. And we've had so many instances where people have come in and they've been working together, and one of the people that was a co-inventor has now gone on to do other things. And the person who is still working on the technology is very much interested in pursuing patent protection. But because they can't get the other person, or maybe the other person isn't sure what they want to do or what their role is, the person who is interested in commercializing it is in a dilemma. do I move forward and file? If I do move forward and file, I have to list both of us because we both are inventors. But if I want to go and get someone to help me fund this, they are going to want to be sure that I have all the intellectual property rights. And if the other person isn't available, that other person still has 100% right to commercialize that in any way they want. So up front, when you're working with someone, if you say, let's just agree that whatever comes out of this, we're going to agree that we will assign it to some kind of an entity that will hold the intellectual property rights. And that is where there's a dilemma, because so often it can be students and or graduate students or even professors who are working sort of just collegially with someone they know at maybe a manufacturing entity, and they're sort of trying to work things out. And so they'll think, well, I don't want to go and talk to an attorney to agree to have a founder's agreement drawn up, and it's complicated. And so, this gets into the realm of real life versus best practice. The best practice is to go to an attorney. But if you can't, at least ensuring that you have an agreement up front and that you understand the risks of proceeding without having it straightened out is a really good idea. And the founder's agreement, which is on the website, has a lot of really good ideas about what you need to think about up front when you're doing that. And it's broken down into pre-company activities, the ownership of business assets, and a decision about whether a company should be created. You can put certain timelines in place so that no one is locked in, but you have a reasonable time period that you're anticipating to make these kinds of decisions. We had a couple of instances where this has happened. And so that's why we got together with some of the professors here and wrote up this guidebook, because people truly weren't able to pursue something they wanted to do because it just didn't make financial sense to invest $5,000 in filing a non-provisional or a provisional patent application, when the other person very clearly, remember, Dom, the one I think had gone to Arizona, was pursuing school. The person kept texting them, trying to call them, emailing them. But at some point it becomes pretty clear that no, we just can't count on this happening.
I've got one, actually an actual experience. I teach at the engineering school, and one of my students worked the summer in a small company. And she came up to me and she said, we were working on an invention and I helped create the invention. And she wanted to know if she would be on the patent. I said, of course, you have to be if you're part of the invention. She said the owner of the company, well, she wasn't sure what she signed when she got the employment. So I'm not sure, she didn't know what she signed, which is important. But he hasn't talked to her about, he wants to patent this. And he hasn't talked to her about it at all, about if she's involved or if she's not involved, and it's a situation where she doesn't, she's young, she didn't know what she signed. She may have signed some agreement that gave him all the rights, but she still needs to be on the patent. And she sort of thought that he wasn't going to do that. So
yeah, employers can have a misimpression that if they have their new employees sign an employment agreement where they agree to assign all the rights, that means they have all the rights and that they don't have to list the employee as an inventor, which is
yes,
absolutely not true.
right.
Yeah.
So the question is, what should the employer do in that situation if she supplied or contributed to a claim on the patent?
Well,
Yeah.
legally he has to put her on the patent as an inventor. If she signed
If she
it,
supplied a claim.
yes, yes. But she feels that he hasn't spoken to her at all about it, and she doesn't think he's going to do that. And so hopefully he has a patent attorney that will ask questions. So, because if her name is not on the patent and she has a valid claim on that, then the patent is void. It's
It can be invalidated if there's any question at all about it that comes up.
so yeah, there was a.
And that was my point. The employer doesn't realize that if he leaves something off, or in this case, one off, that it can be invalidated.
Right, so,
Wow. Yeah, and there's so many scenarios with employment agreements that that people might have questions about, and it can go, yeah, it's also it's in both parties' interests to have it clear about what the expectations are. Sometimes you have people who are working on their own technology that take a part-time job, or even, take a job thinking they'll work for a couple of years, but they're continuing to invent in a space that's sort of adjacent to what they're being hired to do. And most employment agreements will have the employee agree to assign all their IP, to not compete when they leave, to not solicit any of the company's clients when they leave. And some of them even have holdover clauses that say, if you do leave and you invent in this space, we retain rights, or we will have rights to that invention. So especially people who have a lot of experience want to go in and truly negotiate that employment agreement to be clear that they already have IP, that they're continuing to work on IP, and that anything they do outside the scope of their employment will not be covered. And that's going to that may very well require an attorney. The employer, a lot of it depends on how much the employer wants the employee and how much the employee wants to work. And because often the employer is the one in the position of greater power, the courts do enforce these agreements carefully, and they have to be reasonable. They have to be reasonable with regard to how much time after the person leaves the employee is subject to these non-compete, non-solicit limitations. And they also have to be very reasonable with regard to geography. You can't take away a person's ability to support themselves. And so the courts won't enforce overly restrictive employment agreements. So if you're an employer, you probably want to talk to an attorney to make sure that your terms are reasonable. And if you are, engineers coming right out of engineering school aren't going to have a lot of bargaining power, but if you are an experienced engineer taking a position, you might want to take some time to talk with an attorney about this. The other reason to go to an attorney and have the attorney involved in the agreement is because the only reason you have an agreement is to make sure you can enforce that agreement. Sometimes people think it's just paperwork somehow, but two parties coming together to negotiate terms that are important to the commercialization of a new technology are going to want to be sure that when something goes wrong, they have an attorney that's experienced in this space that can help them enforce it. NDAs are something that people almost think are worthless, but they really are, sort of just this formality. But you can't obtain patent protection if you've disclosed your technology to others in a public way. And, maybe Dave, you'd talk a little bit about with what you do if you're dealing with an investor, because of course they are going to want to know about your technology But if you haven't filed for patent protection yet, and they won't sign an NDA, what do you do?
Yeah, so I can think of a couple of scenarios. So generally, venture capitalists will never sign an NDA. So you need to have your ducks in a row in terms of founders agreements and assignment of IP in advance of talking to a venture firm. I ran into a situation where a small firm, 5-company group in Europe, was talking to some very large pharma companies. And they said, well, we really can't talk to you unless you have a prototype to show us. And so they created the prototype, and then they said, well, you know, it has to meet certain criteria. And so they told them what tests to perform. My question for the folks in Europe was, who owns the data? Because it sounded like the large pharma company was actually trying to get enough testing data and the possibility of reverse engineering. And so that's a real danger. And so the NDA is really crucial as you're soliciting potential licensing partners, and they're asking for more and more of your work and performance and things like that. So anyway, I was going to ask Molly and Dom, in that situation, what would you advise the small firm, the 5-person firm, when dealing with the large pharma company?
Well, while Dom's taking a sip, I'll just say, you know, filing a provisional patent application would be the very best protection. Because otherwise, you know, I just think that you are very vulnerable to not being able to get that patent protection when you're going to need it, and if it does turn out well. Dom, is there anything else you can think of?
Yeah, well, yeah, provisional patents are great. They can, we've had a lot of experience this summer where you take university wants to publish a paper, and they need to protect it just in case there's a patent there. So they take that paper and they use it and submit a provisional, which is a great way to protect that information. The problem is, if you don't write it in a form of patents with claims, then you're barred from submitting that as a European patent. So provisionals are great. Save the call it priority date. The date. If you have other people looking at you know, the technology, you know, other people are working on it, and you have a great invention and you want to protect it. So, but there's a simple way to do a provisional, which is just take almost anything that describes the invention, and you have to fill out a sheet that gives the inventor, the date, and it's just a one page basically of information. You attach that to the technology description and you submit it, and it's pretty inexpensive, and it doesn't get reviewed until the non-provisional is filed, and then supposedly, and I've heard different stories, that supposedly the patent examiner needs to read the provisional and make sure all the items in the provisional are in the non-provisional. You can't add information. You can't add inventors. You can take away inventors and you can take away technology, but you can't add. So I've heard that sometimes they don't look that close at the provisional, which, you know, depends on the patent examiner, I guess. So provisionals are great as long as you do it correctly.
As you
And that's
said,
a
as long
point
as you
about the-
apply claims if you want to file overseas.
Right.
Right, yeah, that's really important. And then the other thing, of course, that we remind people is that you just have to say no to providing a prototype. I mean, that just seems, I don't see any way to do that and then be able to get patent protection, because people will think, well, how will anyone know? But it has to do with avoiding it or invalidating it further on down the road. And that's what will happen if you ever try to assert your patent. In a way, a patent is an agreement. It's agreement with the US government that you have the exclusive rights to determine who gets to make, use, sell, and import those claims. And you can stop people from doing that. But if you try to assert that patent against someone that you believe is infringing, that person, that company is going to be very invested in getting an attorney to defend them against that. And the first way they will try and do that is to show that the patent was invalid for any number of reasons. That one of the inventors wasn't listed, that the prototype was, that the technology was disclosed when the person was meeting with other investors.
There are cases where it wasn't reduced to practice. You have it's called a paper patent. You have a great idea and you write it down, but you've never made a prototype. You've never reduced it to practice, which is really, basically illegal. I mean, according to the patent, you have to reduce it to practice, and then you have to put in the best mode. Not only that you have to tell people that you've done this, but you have to actually tell them the best way to do it. And if you've never made a prototype, you don't know what that is. And I've seen cases where another company came in and says, well, I reduced it to practice and you didn't, you got the patent. So you're really, your patent can be invalidated because you didn't do one of those steps. So you got to be careful. And I always tell people they need to do prototypes. People, I mean, because of lack of money, a lot of other situations, you're not able to do a prototype. But if you don't do the prototype before you submit a patent or a provisional or a patent, non-provisional, you can lose certain aspects. I mean, when you do a prototype, you actually invent a way to make it work. That's usually what happens. And those are very important inventions when you actually make it work. And so, prototypes are so important.
So back to my scenario with, the large pharma and the small inventor. My biggest fear was if they showed them a prototype and they didn't have the provisional or their non-provisional application in, and I'm not trying to impugn all large pharma companies, but they could actually say when the patent's filed, oh, we saw it prior to that date. And somebody that you want to license to can invalidate your patent, again, to increase their bargaining power at the table when it comes to licensing. So it's, there's a lot of things for the inventor to be aware of and to watch out for.
Yeah. I'm thinking of two things. One is, a lot of times people just assume attorneys are going to be too expensive and they don't have the money for a contract. But attorneys are looking for business and they understand that technology commercialization and the success of a startup is very good business. So a lot of times they'll talk with you. You can ask them how much it would be. You can tell them what kind of an agreement it is. Because there are these nuances that just finding a agreement on the internet and filling in the blanks can really do you a disservice. The other thing, though, I wanted to talk about with regard to prototyping and how expensive that can be is that there are the research centers that New York State funds. Many of them have rapid prototyping services. They have experts in this area. Those experts are working with PhD students who need projects. So there's capstone programs that sometimes can help with prototyping. There's some that will charge, but for a nominal fee. So it's really worth exploring. The folks at NISTAR, Fuse Hub, we can help make those connections. Most of the research centers around the state would know someone at their institution that could give information on that. So, so that's an important resource, sorry, to pursue. Now, that kind of leads into the whole idea of working with contract manufacturers and those agreements. When you are designing your product, you're trying to figure out how much is it going to cost to produce it. Dom, can you talk a little bit about that in terms of, it's part of prototyping, but it's also part of figuring out how much it will cost to mass produce it. And when you're working with a contract manufacturer, you want to be cognizant of protecting your IP there too.
Right. We had, I had one client, that needed to prototype. It was a medical device. And we contacted a few contract manufacturers, and one near Boston was really, really great. They only work for individual inventors and entrepreneurs. They didn't have their own products, and they had a huge staff that could help to design. And what the great thing about this company, they knew about FDA, and they knew how to design for FDA products. They knew how to keep the records. They knew how to keep the design history file. And they would actually do prototypes, and they would do small production and get it ready for manufacture. So and they would divide it up into pieces. So you could do one piece for a small amount of money, and then if you want to go larger, you can go larger and larger. So contract, some of them are great. Another one we went looking was in New Jersey. They may have their own products, and they weren't that receptive about doing something for an entrepreneur. They did it once in a while. So you really have to find the right contract manufacturer to do this, to do the prototypes. Unless if you can do your own prototype, that's even better, because as you build it, you can figure out what's wrong and try to fix it and make it right and make it work. We had one client last year before, who had got a patent on their idea. It sounded like a great idea. And she went to an engineering firm. I'm not sure where that was. And basically they told her they couldn't, it was impossible to make it with the technology they had today. And she had the patent. She says, well, I have a patent, I want to make this. And she never reduced it to practice. She never made a prototype before she did a patent. She did a patent on an idea, which you really shouldn't do. And found out that she couldn't make it. She had to make it in a totally different way that wasn't described in her patent, which is a problem. So,
yeah, I wonder if she perhaps refiled. That raises all kinds of interesting legal issues, doesn't it? But that's the perfect thing. If she were ever to try and assert that patent against someone else who was doing or solving the same problem, she wouldn't get too far.
So two things on the two things that we've just commented on. I'm aware of some IP attorneys. There's a firm in Boston.
Oh, you froze, Dave.
Huh. Oh, and now my video is gone. What's happening?
We lost Molly's picture. And,
Can you hear
Okay.
me? Okay, there we go.
yep.
Yeah.
We can hear you.
So I'll keep my camera off so my audio stays on. So what I was describing is a firm in Boston, a law firm that will actually reduce their fee that in trade for a percentage of the royalties. So they'll actually help you with filing your patent, and even, finding a potential licensee so that they can get a success fee, a reward fee. I'm also aware of an industrial design firm, one in Cleveland, that has good ties to the Cleveland Clinic, and they will do the same thing. They will help you with your prototype and design for manufacturing by taking part of their professional fee in future royalties. So it's rare, but it can be done, and you can, like anything else, just like in getting financing, you can trade future prospects for work that you need done now. So you just have to find the right partner and the right creative party, and then obviously document.
Right, we get back to the
Right.
importance of having an agreement then, right?
Absolutely, yeah. But
Which
I
does,
was going to say, nobody remembers what they agreed to if somebody got hit by the bus. So, well, people move on, so they change companies, they change interests. So that's the value of having it in writing.
absolutely. And the risk that people take, and again, we get into best practice with real world things that happen, because people roll their eyes when they say, oh, the lawyers are going to have to get involved and review it, and then that will take so much time, that things do sometimes move forward without the optimal agreement being put in place. But even then, an email kind of saying this is to confirm, the different terms that can then be saved can be really useful further on down the line. My video truly won't work, or I'd be holding up our other guidebook, which is the Licensing Guidebook, which is another, once we've sort of been talking about, employing people to help invent, and then making sure that you're protecting the IP when they come, or reaching out to a contract manufacturer to help you invent. And that is another thing, that with the contract manufacturing, you want to be clear who's going to own the intellectual property, that you retain the rights to the intellectual property if you're the one wanting them to do something for you. And I've asked contract manufacturers at different events what they do about, from their perspective, do they want to protect intellectual property? Because sometimes they're a part of the solution. And when you're a part of the solution, that can be an invention. And most of them say, we're not interested in that. We want them to come back. We want them to recommend us. We want to work with people. We're not looking to have our own IP. But sometimes I remember a group from a university that was working with a manufacturer, and the two of them were working away on basically continuing to invent something while designing it at the same time. So they were very much working together without a founder's agreement, without paying attention to the fact that you're having two inventors from two very different institutions. And the university, of course, a professor is going to have to make an invention disclosure, and the professor's institution will own those rights. And even the most savvy institutions that really understand the benefit of getting technology out into the marketplace, still there's going to be a lot of process with who's filing for the protection, the royalty rate, all of that kind of thing. So so we move from those things to when they obtain a patent, then what do you do with it? And it's a lot of fun sometimes when you get a sort of a platform type of technology, and then you get, maybe you want to develop one aspect of it yourself, but you might want to license it out in other geographical areas to be developed, or other applications. Anybody want to talk? For instance, drones can be used to do estimates for roof damage or to install solar cells, to take photographs, to inspect bridges. There's so many different things you can use them for. And one company needs to focus on one market usually. And for a number, for a number of reasons, mainly that they want to be successful, you need to have some amount of focus. So then you're thinking about licensing it out to others to develop it in that way. And when, go ahead.
Patents for applications, which are sometimes difficult to obtain because there still has to be an inventive step for that application. If you just take something and just say, I can do this with it and I can do something else with it, just because you can do something with it without inventing anything or changing anything, that probably doesn't rate an invention. But if you take something and use it and it's not obvious and there's some inventive aspect to it that makes it work in this situation, then you can get a patent on a different application. But those are difficult usually to achieve.
Yeah, and that's, I think, why if you are fortunate enough to begin to build a patent portfolio in a certain area, you want to be sure that you're the one that's controlling how it's used, right? And that's the benefit of licenses. And then you want to, you want to look at what it is that you're licensing to people. Is it the actual rights to all the IP, or is it for the design of it? Maybe you want to license out their ability to use your trademark. Of course, there's software licensing issues. The technology license can be different with regard to geography, exclusivity. Are they the only ones that can use it in this space? Or are you going to also be licensing it to competitors? So if you're the licensee and you're negotiating, you want to have as much exclusivity in the space and in the geographical area as possible. What's the field of use? Defining that as a negotiation point. And then determining the royalty rates is, of course, always, is it an upfront payment? Is it, if it's my intellectual property and I'm licensing it to you, do I want an upfront payment, or am I happy to take royalties once you begin making sales, especially if you're going to have to design it and you're starting from a startup situation.
I was going to say, Molly, that was exactly the situation. So I was with a medical device company. Turn my camera off so my audio stays on. Was with a medical device company in interventional radiology, and we would buy the rights to inventions after they had cleared FDA. So they had some value, but they had never been manufactured, or never been manufactured at scale at the very least. And so what we would often do is we would say, we'll begin to pay royalties after our investment in the upfront tooling has been paid for. And we would have an estimate, reasonable estimate, so that the inventor would know, okay, after we invest $200,000 in manufacturing, then, when you get to 200,001, we begin to make royalty payments. So that's pretty typical in a license.
That's a great example. Well, I don't have anything else. What I wanted to do was just sort of go over with you. Let me just make sure that I covered all the.
If you put the link, or maybe Carly can, the link to the guidebooks that you mentioned in the chat window, that might be helpful to Kathy and Oscar.
Thank you. Yeah. There they are. Okay, so I think
We can see
there's
your slides
some,
again.
yep, I just wanted to make sure that we had touched upon each of these. You know, and again, our center sees these and wants to be able to stress the importance of having the agreements. We don't do them ourselves, but we like to see our clients working with attorneys. It's really important when when you're developing technology to not try and do everything on your own. At least that's what we see over and over again. It's important to have a team, to be getting ideas, to be making sure, as Jack likes to say, that you know what you don't know, so that you can be sure you're addressing it. And so with that, I think we'll thank you for attending. And Kathy, is there anything else you can think of?
No, so what I'm gonna do for the next time, I'm sending out a little more detailed email to tell people this is the next one, which I think is October 14th.
Mm-hmm.
Sounds right.
And asking them directly to send some advanced questions. What topics I have often, they provide Ask the Expert, second Thursday of each month, noon to 1, often regarding legal guidance, IP patents, types of agreements, competitive landscape, anything else? Or should I change that in any way?
I'm not sure what competitive landscape is.
Okay, let me take that out.
I mean, we certainly, having Dave has been wonderful for us because he really is an expert in marketing. And so sometimes there's market questions or market research questions. What's the best way to get market research? We've recently discovered a really great resource in Rochester through their library system that I'll put in the chat next time, unless Carly, I don't know if you have it quickly available, but you know, impressing upon people who are developing new technology, the importance of a target market and the many things that Dave brings to the discussion with our law students about what you want to help your client understand about what they need to understand about the market to be successful. Things like that. And I know that's not, I could be more concise about that, Kathy, for your notice. And then regulatory questions, although truly the FDA is, you know, you have such excellent presentations about that, that I really think that might be better served to invite maybe Brendan or one of the other people you have for an Ask the Expert session on
Sure.
FDA. I'd love to host that. But it's Brendan, and who's the other one?
So it's Gary Brennan. And then we've got some folks at the Research Foundation for SUNY that are helping.
Okay.
Ray Drums is more R&D. And we have Callie Sacco now, who's also one of our new mentors. She's at Hillrom. I don't know if you heard, Hillrom was purchased by Baxter just recently. So we're kind of waiting to see how that alignment will work. I'm assuming it'll hopefully stay the same.
Wow.
They say when they're going to close, Kathy, when Baxter's going to close on the transaction?
All I've heard is it's a done deal. And that they expect the transition to be about 6 to 9 months. That's pretty much all I've heard.
Okay.
So I'm hopeful that they won't move the facility out of Skinny Atlas. I don't see why they would, but we'll see.
Do you know anything? Does anybody know anything about Baxter? I just don't know that much about them.
They're big.
I guess they must
Well,
be.
anybody who can pay 15 billion, I think that was about the price tag.
Yeah.
is either sitting on a lot of cash or very credit worthy. Let's put it that way.
Wow.
But it
All
would
right,
be
well,
good to keep them on our vision and see if maybe we can get them in several ways to be collaborative.
introduce them to all that that
Mhm,
we have here in the region.
mhm.
Yeah. Do we have, well, maybe Callie, anyway, with regard to Callie and Gary, maybe I could email them and ask them if they'd be willing to attend. an
Sure.
SES.
Yeah,
Okay.
that'd be great.
All right, good. Yeah, I think it is better when there is a topic. Our original
Mhm.
idea was, but I think it's, people are always so busy that it's
Yeah.
hard to keep track of the things that come up and then when it is that you can meet to discuss
And
them.
there was a topic that came up previously, and I think it was when you were, Molly, when you were giving the August 3rd presentation, and somebody mentioned it as a potential topic to include, and for the life of me, I cannot remember what it was. I'll have to look back at my notes.
Hmm.
If I find it, I'll get it to you.
Okay, thank you. Good.
Yeah, and it would be great to be a resource to any of your MDIC cohort or their mentors to make it as practical as possible.
Yep.
Because it's interesting as you're going through product and technology development, very often, and I teach agile development, you know, you're saying, hey, here's what I did yesterday, here's what I'm doing today, here are my barriers. And hear people's barriers to know, hey, I don't know anything about this. I need to get a little bit of indoctrination so that I can at least ask a subject matter expert where to weigh in or how to, can be really helpful as you're de-risking your idea.
Attended before your session here, the Johnson & Johnson investment session, which was really interesting. And it talked a lot about recommendations for into the network. So they mentioned incubators, they mentioned all the resources that support incubators. And I think a good topic to bring forward is, I mean, they're talking Series A, Series B, all the stuff. And it's just mind-boggling, all of the different funding packaging. And I'm getting people that are doing crowdfunding, which makes me a little nervous because they're locking in their investment to this crowdfunding for a very certain specific windows and the ability not to accept other investment. And that just makes me nervous that people are doing that. So I think if we could do something maybe as a partnered approach with like the Tech Garden, Jeff Fuchsberg maybe, and get something like that about investment and the legalities and contracts. And they talked about who to go to for guidance, terms. And I mean, a lot of these companies they just don't know what they're locking themselves into. And I don't know if that's something that you guys have dealt with before, but.
And we could do it in, we could make it a panel discussion with Jeff or, you know,
Steve Lickstein.
Hartsock at the
Yeah.
Blackstone Launchpad. A lot of,
Yeah,
she's knowledgeable about the non-dilutive side and how to start with grants before you start giving away equity. So, and Jeff could talk about, you know, convertible debt because that's grants for growth. So yeah, we could do that.
Added.
To get to Series A and Series B, now you're talking venture capitalists, you're finding someone to lead the syndicate. You might start small with, family offices and things like that,
Mhm.
and then go up to, venture capitalists. But not all venture capitalists are created equal. They have different specialties. They like coming in certain rounds. And even if you hear, well, this isn't quite for, a fit for this round, you keep them informed so that when you achieve your milestones, they're ready for the next round.
Mhm.
So anyway, that's something that we could craft in cooperation with others, for sure.
I also added, we did an article the other day on like the, or not the other day, but last year on the ins and outs of crowdfunding. So that might be something to share with your clients too there, Kathy. So it was kind of, what the positives and the negatives of
Perfect.
that.
I am going to send it to my MDIC teams now. But yeah, I'm happy to partner, share the info out, but I think this would be great timing right now. And Jeff and I had talked a few weeks ago, and I mentioned this to him. I'd really like to do an investment. I sent him an email after the J&J program. So if you guys want to delete it, which I think would make sense, that would be great. And I'm happy to help however I can.
So we can
Yeah,
use
that's-
this format
so-
to host something like that.
Absolutely. So we'll work on doing an FDA one and a financing tech commercialization. Trying to get Linda, Jeff Fuchsberg. Carly, I think that's good to add the crowdfunding there as well. Or maybe, I don't know, maybe we should do 2 sessions to divide it up with, what do you think? Well, we can start with one and go from there. Okay.
And I think Steve Linkstein would be a great add too, that you had mentioned.
Yeah.
So, like,
My
see, let's,
hesitation is about, can we pull this together for October or not? Maybe we look to do that in November.
Mhm.
And honestly, if we do Gary and Callie, I'll email them and ask them about October.
Okay, if you need their emails or anything, let me know.
I think I have them from your mentor meetings.
Okay, perfect.
Okay, and great, thank you, Kathy, for sticking with us. And well, I guess you guys, what we probably will end up doing is maybe coming up with 12 topics and repeating them each year, because it's not there's always questions in these areas. It's more a matter of getting people to understand that here's our 12-month schedule, and if you have questions in those areas, hop on. Yeah. All right. We'll get
Perfect.
there.
great.
We'll get there. Thanks. All right. Bye-bye.
Bye.